is law autonomous? Is law an autonomous system in the sense that it operates largely within its own set of definitions and within its own history rather than the history which it impacts when decisions are delivered? If the law is an autonomous system, this does not mean, of course, that the facts of experience never enter into the law's decision. But it does mean, and this is what Felix Cohen was complaining about, that when the facts of experience do enter into the law's proceedings, they enter as legal facts rather than as facts that would be recognized by persons who were not in any way legal academics or lawyers. I am not a lawyer myself, but I know that often when clients come to consult with lawyers, clients tell a story about what has happened to them or about what they desire. And clients always have a sense of what the important key moment in the story is. And often lawyers have a sense also of what is key, but it is not one that matches the client's, because the lawyer is thinking, under what legal rubric can I bring this set of facts? Is there a way in which I could, deploying all of the constraints and resources Burt talked about before, make a case and so forth? And in the course of developing the legal argument, everything that the client thought was absolutely central to her reason for being here simply doesn't make it product.
Does anyone want to react on the panel? I can take one last question. I see two hands. Go ahead, and then, yeah.
Ask your question at the same time. It's
no.
like deciding a confidence case.
Go ahead, and then.
So my question goes to something Professor Neuborne mentioned before, and it's basically this. How can ideas of empathy and related terms be rehabilitated, especially in the minds of non-law fluent audiences? It seems to me that in the last 25 years, the school of thought that goes towards strict textualism has had several very articulate and several very convincing spokespeople, especially for those who are certainly, I guess, invested in Supreme Court picks and legal jurisprudence, but who don't necessarily know many of the bases behind them. And so what you seem to have, especially in a non-lawyer audience, is the idea that the stricter, the better. When you're being more strict, you're being more honest. And that the instant you bring in elements of empathy and related terms, you might achieve an outcome you want, but you're somehow doing something unseemly. And I was wondering if you had any ideas as to how you might change that dynamic and once again perhaps bring the idea of a more consequentialist jurisprudence into vogue instead of merely having that syllogistic machine that you referenced before.
Well, I mean, you ask maybe the hardest question that I know as a test case lawyer. For me, the way I deal with a textualist, first you hit them over the you deal with the textualist by, I think, pointing out the limits of textualism. That textualism purports to be some kind of constraint that really controls in very substantial number of cases. I have lots of fun asking textualists what due process of law means, what cruel and unusual punishment means, and if they could just write it down on a piece of paper, I promise that I will live by that. And of course you can't. Textualism doesn't deal with the kind of open textured phrases that we use in constitutions. If you look at a tough statutory case. In other words, if you let textualists talk just about theory, they'll spin a world in which the text is the touchstone and you don't have to worry about it. The moment you interfere with that theory, with real facts, my favorite way of dealing with a textualist is the great H.L.A. Hart hypothetical. Somebody passes a statute making it a felony to introduce a wheeled vehicle into the park. How many years does the ambulance driver do? When the ambulance driver drives into the park to try to rescue somebody who's had a heart attack, has he violated the statute that says wheeled vehicles from the park? It can't be that way. So textualism can't solve so many hard questions. And the more specific you get with a textualist, the more you show that there has to be something else. Stanley, over the years, has been brilliant in arguing that it's intentionalism. It's why'd they pass this thing? To get a little peace in the park. They didn't pass it so that people would die of heart attacks in the park, so that it's clear that you exempt that person. And once you admit that you exempt that person, then you have to ask whether a motor scooter is, or a bicycle, a racing bicycle, or a tricycle, are all the wheeled vehicles. Textualism doesn't solve that. You've got to go beyond that. The moment you go beyond that, then you say to the textualist, well, then you don't think your knowledge of the world, your knowledge of, is relevant to the decision-making process? And if it's an honest person, the person will retreat. And textualism has retreated immensely. Modern textualism is not a hell of a lot different than purposivism these days. I mean, the intellectual tyranny of the textualists is over. It's absolutely over. They themselves admit that their argument can't answer too many questions.
I certainly agree with that as a conclusion in the philosophy of language. But I took your question to be a question about public relations. And as a public relations matter, arguments against textualism are going to lose every time. Unless you can assign everyone in the country to read the brilliant essays of mine, for example, that Burt was referring to. And although that would be a result, a consummation I would devoutly wish, I don't believe that it's ever going to happen. There's a certain common sense, rough, ready, Anglo-American, knockdown, empiricist appeal about textualism, and no matter how many of us demolish it, no matter how many times Scalia demolishes it himself in the unfolding of one of his opinions, it will rise again and it will triumph.
Look, if the president nominated a on paper sensationally well-qualified graduate of NYU Law School, who had come here on a special scholarship and then returned to her country, let's say Bulgaria, and had spent 20 years being a sensational judge in Bulgaria, whatever their law is. And he said, but she's just absolutely brilliant, and I understand she applies the law in it's unbelievable how good she is. There's just not a chance. And the reason there's not a chance is I'm trying to just suck out, and so all we have is that. And that just doesn't add up to enough. You want someone who can appreciate who we are. And who we are requires you to do more than just know how to do textual analysis or go to law school, you really need to know who we are to appreciate what this dispute is really about, what those words mean to people in the street, how this would work if you actually ruled this way or that way. And I'm saying that in order to really appreciate that in our very complex democracy, you actually have to be able to appreciate all the elements of our democracy. And if you just take, the brilliant Bulgarian jurist, not a soul would think that would be good enough, but that's why. It's because whatever that is, it doesn't attach itself to who we are. And the we are is what I'm trying to say is really important for the sake of our democracy, to have that responsibility and that ability in our justices. Okay?
I wanted to bring us back to the question that Mr. Fish raised at the beginning about Barack Obama's vote against John Roberts. And how would you advise a senator who knows, let's say he has foresight, as Obama did, that Roberts was very predictable. He was going to vote for business in almost every case where there was a business issue against a woman who lost her arm in an accident. He was going to vote against affirmative action. He was going to even vote to read opinions like Brown v. Board of Education as justifying an attack on integration of a school, and so forth. How would you vote And how would you be exercising your obligations to give advice and